very important piece of evidence, and this is why we indeed say that the positions are not reliable. There are other contradictions as well. The assignment of the plot by the collective farm or by the father of the applicant. How many rooms have been in the second floor of this house? 3 or 4. How big was the size of land? 1,500 square meters or around 800? These and other contradictions show, all in all, that you cannot rely on these depositions, and the main substantial basis of the claim is to be denied. And other than the applicant tried to tell us there is no reliable title deed, there is no registration record in regard to the property. There is no copy of the decision of the village council submitted by the applicant. There is no copy of the registry of the village council. Indeed, we believe that, and we are sure that the technical passports which are submitted are forged. The regulation which the applicant claims to be applicable indeed is not applicable, cannot be applied in order to prove the property rights. And their established practice, which they claim to have, does not correspond to the established practice of that time. The village council never ever had authority to adopt a decision on the allocation of lands adjoining the house at all. And the charter of the village council, which suddenly appeared by the applicant, is, in our understanding, not existing. Despite strenuous efforts, we have been unable to locate this charter. Indeed, the newly submitted law relied on by the applicant is unsourced. In this context, we do not understand why the applicant has not explained in previous submissions in which he relied on the USSR Constitution 1977, and now he seeks to rely on this unsourced law. Also, this argument shows that the main reasons of the claim are unfounded. The technical passport is deficient, as I said before. It does not constitute secondary evidence. We have the main argument, in our view, is the wrong stamp of the Shahumyan district and not of the Goranboy district. You know that the name has been changed and the authorities knew that the district structure has been changed. And the passport would have had to show, in order to be valid, the technical passport, that it should have been issued by the Goranboy district of the Republic of Azerbaijan, which is not the case. And to issue such a technical passport during riots in '91, in which, as we know, there was a very dangerous situation in the region, is also quite incredible. Let me switch to Article 8. The government is stating again that in the situation of danger, it is impossible to have access to the ceasefire zone, and all those arguments developed by Professor Shaw are governing also your analysis concerning Article 8. The persisting link with the property concerned, which is necessary for a claim, if a claim of a right to home is done, also hinders the analysis of the violation of Article 8 is given. Article 14, we have to refer again that the legal practice shown in Azerbaijan do not show any discriminatory effect. Let me come to an end, Mr. President. The policy of Azerbaijan in questions of internally displaced persons has been and is always in favor of repatriation of IDPs. Azerbaijan does it on the level of the United Nations General Assembly. Azerbaijan is encouraging to believe also in the society that all displaced people will be able to return one day to their homes. The Armenian society, just the opposite, is encouraged to believe that the return of Azerbaijani people will never ever happen. Azerbaijan has never rejected the issue of the return of refugees and the restoration of their rights, including property rights. For instance, the two resolutions of the United Nations General Assembly regarding the Georgian conflict, in these resolutions, Azerbaijan voted for the recognition of the right to return of displaced people, while Armenia voted against it. And regarding the Madrid principles, I refer to what has been said by my colleague Professor Shaw. Azerbaijan fully supports one of the basic principles, namely the right of all IDPs and refugees to return to their former places of residence. Honourable members of the Court, the present case tackles very serious and important general questions of the application of the Convention. It differs in one main thing of all the other cases of the Court with regard to displaced persons, in one decisive point. This is a case at the line of contact in which there is no access given due to mines and the danger of military attacks. And unfortunately, the power of this court, the power of human rights, do not work out in a situation of military danger. There is no effective remedy and no effective control in such a situation. We would love that it is different, but this is the border of human rights protection in such a situation. Thank you very much.
Thank you, Dr. Lansky. I give the floor to the government of Armenia. I call Mr. Kostanyan.
Thank you. Mr. President, members of the court, it's an honor to appear before the court on behalf of the government of the Republic of Armenia. My government was invited to address 3 questions during the oral pleadings concerning violations of applicant rights under Article 1 of Protocol Number 1, Article 8, 13 and 14 of the Convention. In addition, in our oral pleadings, we will also address those objections as to jurisdiction and responsibility of the Republic of Azerbaijan and the objections as to non-exhaustion of domestic remedies, which the court has joined to the merits in its admissibility decision. Mr. President, I will start my submission with the question on the violation of Article 1 of Protocol 1 and Article 8 of the Convention. The government of Armenia fully agrees with the applicant that there was a violation of Article 1 of Protocol 1 and Article 8. The situation on the ground is unchanged since 1992, when the Azeri armed forces attacked the village and forced the ethnic Armenian population to flee. As it was previously submitted by the Armenian government, Gulistan is under the full control of the Republic of Azerbaijan, and therefore it falls under the control of Azerbaijan within the meaning of Article 1 of the Convention. The evidence provided by the applicant before the court confirms that the applicant lived in Gulistan with his family in the house owned by him, having in his possession land and other property, the fact which is substantiated by the technical passport, a proper document issued by the applicant, to the applicant. The technical passport provides a detailed plan of the house and provides specifications about the land and is duly signed and stamped, which means that respondent arguments in contrary are not substantiated. The applicant also produced evidence confirming that the family of Sargsyan made active use of their property and land, worked in the village, had deposits in the local banks and earned their income mainly from farming. In its decision on admissibility, the court has not disputed the fact that the applicant had no access to his home in Gulistan, since he and his family were forced to flee from the village. In addition, I assert that because of this continuing denial of access to his native village, the applicant was unable to take care of his relatives' graveyards and was unaware of the status of those graveyards. The government of Armenia recalls its previous submissions about the massive destruction of Armenian graves and historical sites. We rely on overwhelming evidence provided by international organisations, such as the European Union, which prove that Armenian historical sites and cemeteries are being damaged, destroyed and subjected to vandalism in Azerbaijan. The most vivid example is destruction of Armenian medieval necropolis of Juga in 2005. These acts of vandalism were condemned by the European Union and were referred by different international and regional organisations. During the course of examination of this case before the court, the respondent government did not provide any evidence proving that the cemeteries of Gulistan are standing and that the graveyards of the relative of the applicant are not damaged or vandalised. It is therefore still uncertain whether or not the graveyards of the relatives of applicants are not damaged or destroyed. Mr. President, I conclude that the respondent government failed to comply with its positive obligation to secure applicants' rights, and continuing the denial of the applicant's return to his home and property or providing redress and restitution violates the applicant's rights under Article 8 and Article 1 of Protocol 1. I now move on presenting questions concerning the jurisdiction and responsibility of respondent government. The government of Armenia and the applicant in their written submissions provide a number of evidence, including a statement taken on 11 August 2010 from the Ankara military officer, which also includes a map of Gulistan with explanations, photos of Gulistan, taken from the military points of Ankara, which are located 700 to 1,000 meters from the village of Gulistan, as well as video recording of Gulistan taken by the Ankara army officer and submitted by the government of Armenia. Confirms that a gorge through which the river of Injachai is flowing divides the armed forces of the Nagorno-Karabakh Republic and armed forces of Azerbaijan in the area of Gulistan. The village of Gulistan is situated on the north riverside of Injachai, which is under the control of armed forces of Azerbaijan. If the provided evidence is not enough for the court to reach a decision, it is the Armenian government position that the court should consider a fact-finding mission in the village of Gulistan. I invite the respondent government to make an official declaration that they will provide to the court all possible assistance and cooperation in accordance with Rule A2 to conduct investigative measures. Concerning the Ankara, of course, Armenia cannot guarantee anything on Ankara's behalf. However, I would like to submit that Ankara courts for a long time already are directly applying European Convention of Human Rights, and as Armenian government has already submitted evidence in Chiragov case, Ankara courts refer to the court case law and base their decision, where applicable, on the ECHR case law. Moreover, I would like to inform the court that despite the fact that Ankara has not yet been recognized as an independent state, its authorities are now in the process of unilaterally ratifying the European Convention of Human Rights, and they will officially declare that they are bound by the European Convention like they did years ago with the Geneva Conventions. Alternatively, it is my government's position that the court may also invite a specialised, impartial organisation to conduct a fact-finding mission for the court and collect information the court needs for reaching a decision.